in the winter session, which was ongoing, or in the budget session, and it should be passed before the end of the financial year. The Speaker, the Honourable Speaker, in her discretion, accepted this suggestion and therefore did not refer this bill to the Standing Committee. So there is a history why this bill did not go to the Standing Committee. And I agree with the Honourable Shri Yashwant Sinha that if this request had not been made, or if the Speaker had turned down the request, this bill would have gone to the Standing Committee and perhaps it would have been reported by now. But now to tell me, or tell the House, or tell you, sir, that in December 2012, when the bill finally has found an opportunity to be discussed in this House, let's refer it to the Standing Committee, I submit, would defeat the very purpose for which this bill was sought to be introduced in December 2001, with the request that it be taken up in that session, 2011, and to be passed in that very session, if not in the budget session. And I think when the objection was raised by Honourable Member Mr. Sri Shaukat Rai on the instructions of Speaker, a ruling has already been given, but the Speaker, in her discretion, has decided that the bill will be discussed and passed in this House. So my respectful request is, while I do appreciate the views expressed by honourable members that perhaps in 2011 this bill could have been referred to the Standing Committee, my respectful appeal is please do not press that argument now. We have got this bill finally listed for a debate in 2012, and it's necessary in the interest of the very banking system that everybody was keen to protect, that this bill should be passed now. These are purely technical amendments, and I'm willing to explain each amendment to say that no major changes are being brought about except to fill the gaps which have been found in the working of the bill. The second point is, this bill means no harm to any farmer or any poor lender, because by definition, these bills do not apply to loans of less than rupees 10 lakhs. The FASI doesn't apply to a loan of rupees 10 lakhs. And the Debt Recovery Act does not apply to loans of less than rupees 10 lakhs. And I'll read the section to you. Section 1, subsection 4. The provisions of this Act shall not apply where the amount of debt due, etc., is less than 10 lakh rupees. And in the case of SARFAESI, by virtue of section 31, the Act does not apply to any security interest created in agricultural land. Therefore, these acts really do not mean any harm to any poor farmer or any poor borrower. These acts do not mean any harm to them. These acts are intended to recover large loans, especially loans from the corporate sector, especially loans which have been borrowed and then there is willful default in paying these loans. So there has been extensive consultation with banks, with the RBI, with the DRT itself, because the DRT is the one that deals with these cases. And therefore, after that, these amendments were drafted in the year 2011, and that is how the bill has been brought. Now, Mr. Adsul asked a question. I didn't want to interrupt you. You asked a very valid question. Why is the multi-state cooperative bank notified, and why are other banks not notified? The answer is, they have been notified. Under section 21C, bank means such other bank which the central government may by notification specify. By a notification dated 28th of January 2003, cooperative banks have been notified, and by a notification dated 17th May 2007, regional rural banks have been notified. So all the banks are notified. So I'm grateful to you for your support. This is the only issue on which you wanted a clarification. I'm happy to give the clarification. Yes, NPAs are a problem. But NPAs in this country have been well under control when the economy was doing well. between 2006 and 2011, the NPAs have been controlled to below 3%. In 2006 March, it was 3.48% gross NPA. Since then, for 5 years, it was below 3%, 2 point. Let me finish and then.
See, please, please, please. Nobody disturbed you when you were speaking.
We already disturbed. Honorable Minister may be delighted to let us know the volume. It is a juggling of.
It is not a, no, let me finish, sir. Let me finish. I heard every one of the 13 members. Let me finish and then you can ask if any questions. 2.66%, 2.39%, 2.44%, 2.5%, and 2.36%. If the volume goes up and if the percentage of NPA remains the same, it means the total lending has gone up substantially, and that is why the percentage remains the same, or roughly around 2.5%. The 2.5% NPA, gross NPA, in a developing country is not unusual. A 2.5% NPA in a developing country is not unusual because there will be a certain amount of defaulters in different sections. Farmers, self-help groups, even self-help groups. Among the best repaying groups, there is an NPA of between 1 to 2%. Do you then say the entire self-help group movement is a willful defaulter? No, you don't say that. There will be an NPA of 1 or 2%. If everybody pays the loans, there will be no NPA, but I know of no country where everybody repays the loans. And net NPAs were well under control, a little over 1%, because the banks were providing and the regulator for many years. I mean, I don't take any credit for this. Every successive finance minister can take credit for this, because the regulator has been very strict and provision has been made to keep net NPAs only a little over 1%. What has happened in the last couple of years is, because of the challenges to the economy, because of the stress in the economy, several sectors are not doing well. And because several sectors are not doing well, gross NPAs have indeed risen above 3%. It is now about approximately 3.5%. But even so, because we make provision, because the RBI is very strict in requiring the banks to make provision, net NPA is still only 1.62%. The gross NPAs are over 3%, 3.5%, but net NPA is only 1.62%. The effort is to ensure that sectors which are under stress are helped to get out of this difficult time. Units which are making money, we must recover the loans. Units which are genuinely stressed must be helped. I did answer a question. I said there must be some hand-holding in a time of stress so that they all don't become bankrupt or insolvent. They come out of the stress. We have to protect employment. We have to protect jobs. We have to protect manufacture. They will come out of the difficulty once the economy recovers. We are going through a difficult time, and it is this difficulty which is reflected in the rising gross NPAs. But let me tell you, thanks to the RBI and thanks to the strict vigilance, thanks to the provisions made, net NPAs are well under control, and there's no reason to think that our banking system is in difficulty. In fact, many members rightly complimented the banking system. When over 1,000 banks failed in the United States, not one bank in India failed. Not one. Not one failed because good regulation, that's what I'm saying, because of good regulation.
Please
Listen to me. Please listen to me. Good regulation, good governance, good provisioning, and the growth of the banking system so that more people are depositing money and more people are able to borrow money. Sir, banks are expanding. When banks expand into newer areas, there will be some difficulty in the early years. In fact, in 2009-10, we opened 5,192 new branches. 2010-11, 5,314 new branches. 2011-12, 6,503 new branches. We are opening new branches at the rate of about 20 branches per day. 20 branches per day is not easy to open. 20 branches per day are being opened. Even so, there are many parts of India which are unbanked. We must open many more branches. It is our intention to open many more branches. Sir, the question was asked. Frankly, as Mr. Atsul rightly pointed out, there's nothing controversial about any section. The sections are self-explanatory. In fact, nobody had any serious quarrel about any of the amendments, the substance of the amendments. So it's perhaps not necessary for me to detail each amendment. There is nothing very controversial about each amendment. There were some larger general issues raised. Who are the ARCs? There are 14 ARCs. One ARC actually has 60% of the business, and this is an ARC, ARCIL, promoted by the public sector banks. So the biggest ARC in the country is promoted by the public sector banks. That has almost 60% of the business. Other ARCs have now come into being. They will, of course, get their share of business, but there are 14 ARCs. Next question is there a regulator for ARCs? Yes. The Reserve Bank of India is the regulator of ARCs. They have to get a license from the Reserve Bank of India, and the Act provides how the Reserve Bank will lay out guidelines to regulate the ARCs. Now, Mr. Nirupam, is he here? Yes, we got here. He asked about a report on the working of ARCs. Yes, there was a committee which looked into the working of ARCs. They pointed out that certain accounting methods followed by the ARCs were not in conformity with the standards. That report has been accepted, and the accounts of the ARCs were recast in accordance with ARCIL's accounts were recast in accordance with the recommendations, and RBI has accepted the recast accounts. There was some reference to adjournments by Mr. Sampath. But I don't know, I think in one breath I think he's pleading for poor lawyers who want more adjournments. In another breath, in the same breath, he's pleading for the banks who have to recover. In the same breath, he's pleading for the defaulter. The point is, I think Pinaki, where's Pinaki? Pinaki's not here. He said 64,000 cases are pending. Now, why are 64,000 cases pending? One is inadequate number of DRTs. I agree, more DRTs must be opened. We will open more DRTs. That requires infrastructure, finding judges, etc. But we will open more DRTs. I will look into your request that one more DRT should open in Kerala. But cases are pending because the cases drag from weeks to months and from months to years. Therefore, we are limiting the number of adjournments a case can take. You see, all these cases are where the security interest has been secured by a number of documents. There's really nothing by way of evidence to be given. It's all documented loans. Any number of documents are there to show that the person has taken the loan and the person has defaulted. Therefore, we're putting a cap on the number of adjournments a person can take. How many adjournments should a case take? We said if there are X number of respondents, limit the adjournments to 6. Otherwise, limit the adjournments to 3. You know, what is wrong with that? Someday or other, these cases have to be decided. We can't go on giving adjournments for the sake of asking. Then why not 64,000? Yeah, 640,000 cases will start pending. These cases should be disposed of in 1 or 2 hearings. Because they're all perfectly documented cases. There is really no great controversy about these cases. Therefore, I think the provision limiting the number of adjournments is a wholesome provision. It does not deny the borrower a right of a complete inquiry, because 6 adjournments, is that not enough to dispose of a case? So I would respectfully request my fellow lawyer member, Mr. Sampath, not to make an issue, why am I limiting the adjournments? In fact, we should limit the adjournments so that the cases are disposed of. Then there was a question about pendency, I've said. SARFAESI Act has overriding effect. If you looked at Section 35, this was asked by Pinaki again. Section 35 of the SURFACI Act does give this act overriding effect over other laws. Now, he said you must take away even the writ jurisdiction. That's not possible. I mean, he knows better than I do that
Please, now don't disturb.
you cannot take away the writ jurisdiction.
What is your, nothing will go on record, please. Nothing will go on record. Except minister.
We cannot take away the jurisdiction of the High Court or the Supreme Court under Article 226 and Article 32. We can only take away the powers of the civil court. The powers of the civil court can be restricted, but we cannot restrict the powers of the... Please listen to me. I know you're an eminent lawyer, but please listen to me. No, I don't claim that at all.
Honorable Minister, please.
We cannot restrict the power of the High Court and the Supreme Court. Therefore, we have to leave the power under Article 226 and Article 32 intact. But the powers of the civil court have been overridden, and this tribunal will have powers to decide these cases. So there was some reference to a couple of companies, individual cases. It may not be proper to discuss any individual case, but let me assure you that in no case will I allow any special favor to be shown. The particular case that was mentioned, where there was a huge NPA, the strictest action is being taken, both by the banks, in asking them to put up the money up front before any kind of accommodation can be given. No fresh loans are being given. And in fact, the tax department has taken severe action in attaching those assets. So no favors are being shown to anyone, irrespective of whoever he may be. The law is taking its course. So as far as the merits of the amendment are concerned, I respectfully submit that perhaps it is not necessary to discuss the merits of the amendments. These amendments are purely are amendments which have been made to make the Act more effective in its working and to plug the loopholes that have been discovered in the application of the Act. These amendments are intended to help the banks. The banks have been fully consulted. These amendments have been intended to help the DRTs quicken the process. The DRTs have been fully consulted, and I would therefore request that these amendments be adopted. If at the stage of third reading, if anybody has any difficulty about any particular amendment, I'm willing to explain the amendment, but otherwise these amendments are self-explanatory, and I respectfully request that the House kindly pass these amendments.